Taruni, please rename yourself.
Yeah, doing it. Thank you.
Manya, please rename yourself.
Yeah, I'm doing.
Okay, Manya, could you add your code, please?
Dear teams, we are about to start. Please turn on your cameras. All participants, please please turn on your cameras. Dear all, and my respected judges, welcome to the final rounds of 6th edition of S.K. Misra Memorial International Mediation and Negotiation Competition. I congratulate all the finalists who are here today and going to compete in the final rounds today. We have Shilpa Mehra ma'am joining us as judge. We have Miss Iram Majid ma'am joining us as judge. We have Mia ma'am joining us as judge. And we have Hana ma'am joining us as judge. We also have Mamta ma'am joining us as a judge. She has joined through another platform and she is looking after all of your performances right now. She'll try to log in through Zoom very shortly. So wishing all the participants good luck. With the prior permission of all these team judges, we would like to begin with the final rounds of the 6th edition of our very own S.K. Misra competition. If the judges permit, can we start?
Yes, please.
On the count of 3, the participants may start. 3, 2, 1.
To start off, I welcome both ZIL and MPDC to this mediation. I'm so glad to see the both of you here, especially considering the hiccup the both of you went through with arbitration prior to this. I think it really shows that choosing mediation as your preferred form of dispute resolution really points to your commitment to providing sustainable energy to your state. And I think that is the fundamental of what this mediation needs to hold as well. This is a problem that is bigger than both the parties. It concerns the environment, and ultimately it will concern everyone in the state. With that being said, I would like a quick round of introduction so we can familiarize ourselves. I'll start with myself. I'm Taruni Athreya. You can call me Taruni. I will be co-mediating this round with Marcus Field, who will now, I will hand it over to.
Hello, everyone. I'm Marcus Field, your co-mediator. You can call me Marcus.
The requesting party can go ahead, please.
Hello, everyone. Good morning, good afternoon, good evening, based on your time zones. I am Manya, the Executive Chief of National Power Development Corporation. My pronouns are she/her, and please feel free to call me Manya. I hereby affirm the absolute and unqualified authority to make any decisions and agree to any arrangement that we might hopefully reach today.
My name is Sadhul. I am the counsel for the NPDC. I am here in a merely advisory capacity, and all of the decision-making authority that lies with us today lies with Manya.
Hello, everyone. Am I audible? Great. My name is Gyanesh, and I'm the lead project manager of Zenith Infrastructure Limited, or ZIL. I want to affirm that both me and my counsel Siddharth have the full and requisite authority to be in this mediation sessions and take requisite decisions.
Greetings to everyone present here. My name is Siddharth. I'm the counsel representing Zenith Infrastructure Limited and Ganesh in today's session. My preferred pronouns are he and him, and you may refer to me as Siddharth. Looking forward to a great session.
Thank you for that, everyone. That was nice. That was a lovely little intro. I will now explain to you the principles of a mediation. To start off, I'd like to confirm and inform whether everyone is here on their own volition because it's a completely voluntary process. Secondly, we've left the court and we've left the courtroom drama behind us. It's completely confidential. Whatever we talk about here is going to remain here. And if you see us taking notes, it's only for our clarity and for your clarity's sake. They'll be discarded right after. Third, it's a client-centric process. So while we're here to help you and guide you, you are the ones who are going to be conducting this discussion by yourselves. So please make sure to have your priorities already set, because while we're here to have an open dialogue, we are on a time crunch and we do have a schedule. So we want to hope to have the most pressing conversations out in the beginning. With all of that said, I just want to highlight our role as mediators just one more time. Think of yourselves as an embodiment of the river itself, the river in dispute. We are just the controllers of the dam. So while we can help you with the flow of the water and the speed and the amount of the water, the curves and the ebbs of the river, the direction in which it goes is completely up to you. So we're here to help you, but we're not here to impose our ideas on you. It's a conversation between the two of you. We're just going to be watching from the bystand, helping you make the most out of it. With that being said, I will now hand it over to Marcus to brief you on a few procedural aspects of how this mediation is going to go about. Over to you, Marcus.
Thank you so much, Taruni, for such a beautiful beginning of this session. I hope so, parties, you do not find any difficulty in joining this meeting. And parties, I can see that we have joined this meeting from different parts of the world, and because of the language, because of the accent, or because of any other specific information, if you find lack of clarity, please let us know. We will more happy to accommodate any kind of such need. It's well said that an ounce of mediation is worth a pound of arbitration and a ton of litigation. Mediation helps in understanding, communication, and forms a mutual ground. Unlike arbitration and litigation, mediation is voluntary and a confidential process. Now, parties, I just like to give an analogy so that you can understand this process in a better way. Mediation in this dispute is like reinforcing a skyscraper under construction, addressing design changes, unexpected weak foundations, and evolving safety regulations without tearing the entire structure down. Instead of letting rigid position weaken the project integrity, mediation acts as a structural support, ensuring both sides adjust while maintaining stability. By focusing on collaborative problem solving rather than adversarial battles, mediation prevents costly collapses, aligning interests so that the project reaches completion with a framework that stands strong for the future. I hope so, parties, this analogy help you to understand what the mediation really is. Parties, now my question is it your first time you are visiting for any mediation session? Okay. So I just like to explain some of the rules, procedure, which we are going to follow in this session. Parties, is the screen visible to you? Just give me a second.
Yes, it is.
It
Yes.
is, it is. Yeah.
Okay. So this process is of 75 minutes. So we will begin with the opening statements, and I just request both the parties to share the minutest of the hardship, the issue you are facing, which help others to empathetically imagine themselves in your position and helps to craft more amicable resolution. On the basis of opening statements, we the mediators set neutral agendas, and agendas are nothing, these are just the flow of information, and it's up to the parties if they want to add, eliminate, or remove any of the agenda, they can tell us and we shall oblige to that. And it will be followed by joint discussion. And parties, if you stuck in a deadlock where you do not do further conversation, we will call for private caucus. And a private caucus is just a private discussion between mediator and each party. And the other party will leave the room. And the time allotted for this private caucus is 15 minutes, which means 7.5 minutes per party. And we, the mediators, try to allocate and provide you the fair and fixed amount of time. And what will you tell us in this private caucus? It will remain confidential, as my co-mediator already said that. And it's up to the party when they want to call it. Otherwise, if the need arises, we will call it for you. Now, parties, I just like to share some of the ground rules and that we are going to follow in this session, as we are having this meeting in virtual mode because of technical difficulties and network issues. Sometimes the things get worse. So firstly, if one party faces disconnect, we will wait for 3 to 5 minutes for that party. And secondly, I just request to please speak at slower pace, which help other to understand what you are saying. And thirdly, please provide uninterrupted period of time to other party and follow some common rules of courtesy or respectful behavior. Please do not use any unparliamentary language and inflammatory language that may harm other parties' feeling. And as my co-mediator already said that it's a voluntary process. So we will not force you. Give me a second, parties. I just like to project it with a chart. Is the chart visible?
It is.
Yeah.
Yes,
Yes.
it is.
Thank you so much. So as my co-mediator already said that we the mediators are neutral. We will not have any stake in outcome. We just facilitate in communication and negotiation. And parties, you can see that this session is being recorded. So it's for our convenience and we will delete it after concluding the session. And it's a party autonomous process. And what I mean by party autonomous, parties, you are in complete autonomy. What kind of decision you want to make? It's a voluntary process and it's a non-prejudicial process. What will you say here? It will not be used as an evidence in any court of law. So parties, lastly, I just like to add a suggestion from my side. Please be open, flexible, solution oriented. As mediation is more like mining. So you have to dig deep until you get something valuable. And what you have valuable today is the information. And the more information you put on the table, the better the result it will be for you. And you cannot shake your hands with a clenched fist. So be open, flexible. Please do not rigid your positions. I think I'm done with the rules and procedure. If there is any query, I'm happy to answer that. Otherwise, I think we can begin with the requesting parties opening statement as it's a convention.
Yes, I think, Madam Mediator, we are good to go. No questions from our end, if the responding party is okay with it.
No questions as well. Thank you.
Okay. So, as I said, I am Manya, and you all can call me Manya. At the outset only, I would like to thank everyone present here on a very relaxing Sunday afternoon. You know, it shows our unwavering commitment to resolve the issues, to resolve the knots which have come into our business relationship, our contractual relationship. Special thanks to them, Special thanks to the mediators as well, who explained the very complex process of mediation so well and created this whole environment of reassurance. I mean, I was talking to my counsel, Sadhil, yesterday night only, that I was a little afraid, by this idea of mediation and how complex it is. But I am very reassured right now. And thank you to the mediators for that. So, I would like to start by saying that great projects aren't just built with steel and stone. They are built with trust and teamwork. The Goret hydroelectric project was never just about power generation. It was about progress, partnership, and purpose, bringing sustainable energy to thousands, fueling industries, and driving development. We embarked on this journey with Zenith Infrastructure Limited because we believed in collaboration and building something bigger than ourselves. But partnerships like power plants need a solid foundation, right? And I think Ganesh will agree with that. Do you mind calling you Ganesh? Yeah. So, and that foundation here is the contract. A commitment, a blueprint, a shared responsibility. It's not like a revolving door where terms can be bent, reinterpreted, or walked away when inconvenient. It's a promise that must be kept as it ensures fairness, accountability, and trust. And this is something that I was discussing with Sadhil earlier in the day as well, right? Yet, here we are today, faced with disputes over scope of work, financial claims, insurance deductions. What are challenges? Absolutely. Did things change along the way? Of course, they did. But a contract isn't just words on paper. It's the guiding principle that keeps projects like this on track. So, what is that we want to discuss today? So as to set the tone of the mediation to avoid any confusions thereafter. I believe that there are certain issues with respect to scope adjustments. The facts can be delved into later on. I do not want to take much time given that we have a paucity. And then further, we have issues related to certain unforeseeable events that emerged during the construction work. And Ganesh, trust me when I say, I know what kind of things businesses have to deal with. However hard things get, we have to deliver, and how unforeseeable circumstances can hinder the whole process, no matter what our intention is. Lastly, I believe that there are some insurance responsibilities that are to be taken care of. And most importantly, for us at least, how can we resolve this efficiently and get back to completing this crucial project? As Madam Arbitrator said that we have a time crunch today, we believe that the time crunch is not just limited to this mediation, but the completion of the construction project as well. Because at the end of the day, this isn't just about claims and counterclaims, right? It's about keeping our word, completing the project, and delivering on the promise of progress. Let's talk, not as adversaries, but as problem solvers, and that is how we come here. Because in the end, this isn't just about winning. I mean, that could have been done in litigation or arbitration. Those methods didn't prove to be very successful. It's about powering the future. At this point, I do realize I have a tendency to talk a lot. So on this note, that we propose solutions which uphold integrity and fairness and account for the interests of both the parties, I would now yield the floor to my very trusted counsel, Sadhil, who shall articulate the agenda to be discussed today more succinctly. Thank you very much.
Thank you. Good morning, everyone. My name is Sadhil. First off, huge thanks to the mediators for helping us organize this discussion. And additionally, we would also like to thank Ganesh and Siddharth for agreeing to finally resort to mediation, because as we've discussed, there have been hiccups in arbitration, and I believe we're past litigation as a strategy regardless. So I have the privilege of representing the NPDC today, and we are gathered here with a shared purpose: to find an equitable resolution to the disputes that have arisen from the 𝐒𝐒𝐿 project. And while differences have brought us to this table, we remain committed to constructive dialogue, and we aim to resolve these matters amicably. Now, at the heart of this dispute lies a series of interconnected issues that have strained the working relationship between the two of us. However, it is essential to remember that the success of the 𝐒𝐒𝐿 project remains a shared objective. We deeply value the contributions that you have made, and your expertise has brought the project very close to completion. That said, we also recognize our responsibility to ensure that public funds are used prudently and contractual obligations are respected. So the disputes before us are not merely financial claims, right? They're about the fair and consistent application of the terms both parties agreed upon. Now, we are confident that the contractual framework provides clarity on these matters. However, we are interested in focusing on what your interpretation is of the same. So as Manya mentioned, we believe that today we can focus on three main issues. Firstly, with respect to the scope of work and loss of profit. Secondly, with respect to the geological overbreak payments. And thirdly, with respect to the insurance deductions. I believe that those are issues that both parties are inclined to discuss. And I hope that you'll take it up accordingly if you have any issues or if you have anything else to mention with regard to these.
Yes, thank you so much.
Thank you to the both of you for putting forward your interests and your priorities. I think from what I'm gathering, your fundamental goal remains the same: to be able to harness and provide sustainable energy. And I think in that I can also sense that you do intend to maintain your collaboration with the other party as well. With that being said, a lot of your interests did come from a place of contractual reliance. I think that is the basis for a lot of your claims. And your agendas, correct me if I'm wrong, are to discuss the scope of work and the losses that have been incidental to it. Second, the overbreak payments. And thirdly, insurance concerns. Correct?
Right, we affirm the same. Thank you, Madam Mediator.
Thank you. The responding party can now go ahead with their interests and priorities, please.
Yes, great. Good morning, good afternoon, and good evening to everybody present here. I would like to thank Manya for reminding the amount of time zones. So thank you so much for that. And greetings to everyone accordingly. First off, obviously, I would like to thank the mediators for explaining to us about the entire process of mediation and to make it less daunting, to be very frank and honest. I was very apprehensive about the process of mediation, especially after the fact that we have had multiple recourses to arbitration. However, I would like to push forward the fact that you, the mediators, have put me at ease. You have made me feel comfortable, and you have made me feel much at home at the very outset itself. Thank you so much for that. I believe that you guys have created an environment which gives a very conducive stage for both the parties to share their thoughts freely and thereby to reach to an amicable solution as well. Secondly, I would like to extend my gratitude to Ms. Manya and Mr. Sadil for joining us today in this mediation session. I understand that there have been certain differences between the two of us in the recent past, and I'm glad that both of us are sitting here on this mediation table rather than circling back and forth in courtrooms. Ms. Manya, for a brief moment, I would want you to imagine the framework of a bicycle. Now be with me for a while. The framework of a bicycle comes with one specific function. Both the wheels of a bicycle have to function properly and effectively together for the framework to be effective. Now, even though the scale of a hydroelectric project is much larger than a bicycle's framework, it follows the same principle. A proper coordination between the executioners of a project, like me and you. I believe that both the ZIL and NDPC have worked tirelessly for the fast and effective building of Goliath 2, our hydroelectric project. Both of us have had a shared goal of making this project reach to its conclusion one day at a time. I was very pleased to hear your perspectives and concerns relating to the issues at hand. And following suit, I would like to give a brief background about our perspectives as well. While NDPC was equipped with the responsibility of taking care of planning, promoting, and executing this landmark hydroelectric project in general, we at ZIL were focused on ensuring the proper completion of the civil works in relation to the project. Fortunately, we were selected as the preferred party in the competitive bidding process, which gave us this valuable chance of showcasing our expertise in large-scale infrastructural projects. As things went smoothly for most parts of the project, differences arose at the later half. With a slight delay in the completion period, we were all set to hand over the project by March 2023. However, we were a little taken aback by the notice of losses concerning the deviations in the scope of work sent by the NDPC on the 24th February 2024. Now, what initially seemed like a minor issue, it snowballed into something major with the flowing of other concerns sprouting from the insurance and the BOQ clauses. Certain additional grounds of insurance were unilaterally added by the NDPC to shift the burden of insurance on us. Additionally, the reluctance of NDPC in addressing the excessive concreting charges also put us in a bit of apprehension. However, today here we come with a clean slate. We are sitting here to look forward into the direction of going forward and ensuring that both the parties are equally benefited from a mutually amicable solution and an agreement. Despite these recurring concerns, I have full faith in NDPC's management that we will be able to solve these issues amicably. I'm sure both of us realize that dragging this issue further into a legal dispute would be detrimental to both the parties. And hence, because of the very same reason, we are sitting here to solve our differences and focus on our future collaborations. In conclusion, I urge all of us to approach this mediation with an open heart and an open mind to find a shared goal of finding a balanced solution. We are confident that with the expertise of the mediators and the good faith which already exists between the parties, we can certainly reach a mutually amicable agreement. I would also want to say that we should not be keeping time crunch as a specific constraint for not letting our hearts be open and speaking our minds to its fullest. Because we believe that we have come as a recourse to this mediation session to be open, to be free, and to solve our differences in the past. Thank you for your time and consideration. I would now like to pass the baton to my friend, my counsel, Siddharth. Please take over.
Greetings to everyone present here. I am Siddharth. I'm the counsel representing Gyanesh and Zenith Infrastructure in today's session. What I would be doing in this session is assisting Gyanesh and ZIL in some technical aspects in the mediation session today. That being said, I would like to state that I am here merely in an advisory capacity, and the real decision-making power lies with Gyanesh. At the very outset, I would like to thank the mediators for facilitating this whole setup for us. I believe that your lucid explanation of the process and the benefits of mediation has certainly assisted Gyanesh, who, as he mentioned, is very new to this process, and he had certain apprehensions as well. I would also like to thank Ms. Manya and Mr. Sadil for looking at mediation as the preferred mode of coming to an amicable settlement. Your intention to come for mediation itself shows that after everything that has happened, you are here to work with us to find a mutually agreeable solution and end this dispute once and for all and resolve every concern that we have. Given that this process is under the AppCam rules, we also have a digital administrator here with us who has helped set up this whole virtual mediation setup. We are extremely grateful to you as well, and we recognize that without you, we would not be sitting here today. Now, having been a part of almost all the infrastructure projects undertaken by ZIL, of course, under the guidance and supervision of Gyanesh, I have seen how meticulous he is in terms of the work done and the execution of every project that ZIL takes up. The approach taken by ZIL is more often than not focused on the broader perspective of why a project is undertaken, and often includes certain personal touches made by ZIL to make the project better. However, we are currently facing some hiccups concerning the way that ZIL has handled this project, and I believe that you have some concerns as well. We understand and acknowledge that you have concerns, and this is exactly why we are here. We hope through this mediation session, we engage in a fruitful discussion where we can explore solutions that would work out the best for both of us. On that note, the primary concerns that we wish to discuss are firstly regarding the insurance, addressing concerns surrounding the terrorism risk coverage that was unilaterally imposed on us. Secondly, compensation for the additional concreting that we did in the geological overbreaks. And lastly, we wish to discuss the concerns surrounding the scope of work. We hope that this order is already noted by the mediators. And we also hope that these issues can be discussed in this session with the help of you, of course. Hoping to have a wonderful session and walk out of this mediation with a mutually amicable solution. Thank you so much.
Thank you so much, responding party. Could you please repeat the third concern for once again?
Sure. The third concern that we have is surrounding the scope of work. Now, we would like to discuss the first agenda to be insurance addressing concerns surrounding the terrorism risk coverage, then the compensation aspect, and lastly, the scope of work. If that order is absolutely clear to everyone, we would be more than grateful.
Thank you so much. I just like to summarize. Firstly, as your client said that NDPC and ZIL work tirelessly to make this project reach the conclusion, and ZIL focus on completion of civil works. And because of their slightly delay, so firstly, the issue was insurance dispute, as NDPC has unilaterally added this terrorism risk because of that and deducted the payments. Secondly, you want reimbursement of the additional concreting. And the thirdly, surrounding the concern of the work. I hope so. I've completed and written all the things. And if you'd like to add anything.
Madam Mediator, it's actually concerns regarding the scope of work.
Yeah.
Yeah. Thank you so much. So after listening both the sides, now we, the mediator, like to set some of the neutral agendas. And of course, it's a suggestion from my side. And it's need approval from my co-mediator and from both the parties. So firstly, the financial equitability and contractual compliance. The second is scope and work variation adjustment. And the third one is risk allocation and policy compliance. Will it work?
Madam Mediator, I believe that both parties are aligned in that we want to discuss the scope of work, the overbreaks, and the insurance individually. However, I believe the disagreement lies with respect to the priority we place the three. I believe that we can discuss the scope of work preliminarily solely because there is less ambiguity in the contract itself regarding the same. If that is amenable to the
Yes, it's a completely fluid process and we can discuss it firstly.
Most certainly, we are okay with the set agenda.
So just to clarify, the new priority order would be,
the scope of work, the overbreaks, and then insurance.
is that
Yeah.
fine?
Yeah, we would
We are
give
good.
that.
We are good.
Thank you.
Co-mediator, could you please write it in the chat box?
I
Which
will.
help the
Yes.
parties. Thank you so much.
While I put it down on the chat box, if you would like to begin speaking on the first agenda, which is the scope of work, you can do that.
Thank you, Madam Mediator. So, hello everyone again. I believe that we are all aware with the facts of the case. However, just for clarification, I reiterate that there has been certain disagreement with with regard to the scope of work, as in Zenith has changed the scope of work by a certain considerable margin, that is 18%. Yes, 18%, and due to which it has incurred some extra expenditure, which forms the basis of their claim of compensation. Please correct me if I'm wrong, Ganesh.
So we have not incurred any additional or an extra expenditure with regards to the same.
So I'm not able to understand what forms the basis of the compensation then, if no additional costs have been incurred due to change in the scope of the work.
Miss Manya, I would just like to ask, given the situation, firstly, if you could explain the current situation and the concern that you have regarding the scope of work and what can be done to resolve the situation. It would maybe clarify everything for everyone's convenience. Then accordingly, we can proceed with the issues. Yeah.
Thank you, Counsel. So, given that I do not really have much in-depth knowledge of the legalese involved here, I would try to provide a clear framework of what is the dispute at issue. So, what the scope of the work, which has been defined in the contract that we both as companies entered into, has been reduced by 18% by your company, which led to incurring of costs and hence your claim of compensation. And I would like to ask my counsel to read that particular clause in the contract which mentions about scope of work. I think that will clarify more.
Absolutely. If I could direct you to clause 12.1.
I think just the mention of the phrase works.
Absolutely, absolutely. But if I could direct you to clause 12.1 of the contract, the rates stated in the bill of quantities cover all obligations under the contract, including materials, labors, and contingencies, unless stated otherwise.
Yes, so the bill of quantities and everything related has been covered under the clause. However, as Madam Mediator said, that contract is the basis of the dispute. We do not want to seem like we are asserting as stubborn people on enforcement and strict interpretation of the contract. Neither do we doubt your intention. We are all here in good faith, and that is why the mediation, right? I believe that this dispute is about interpretation and not intention. So as to avoid any further confusions regarding the facts and the contract and the interpretations, I would like to ask you, how do you interpret the terms which Sadhil mentioned? Materials, I quote, materials, labors, and contingencies unless otherwise stated. Because I see that there is something that we are unable to notice, which probably you have. So if you could provide us clarity regarding the same, we do not want to impose any unjust allegations on you. So yes, over to you.
Thank you so much for clarifying all the ambiguity surrounding the scope of work. To provide further clarity of what exactly happened in relation to that specific clause, was that NDPC essentially or initially, what they did was we discussed, deliberated, and on itself had foreseen certain sort of an expenditure which was to be made termed under the scope of work. Following suit, it made such expenditures and then it shifted the focus to us, which is ZIL, to use those raw materials in the scope of work and then essentially continue with the construction and the project of hydroelectric plant, also the dam, also known as the dam. Now, at ZIL, what we believe in is efficiency. What we believe in is trying to use as less of resources as possible. And I think that's one of the reasons why you chose us as the party as well. So following suit, what we did was we went ahead and we tried using as less of the resources as possible, which ultimately led to an 18% deviation from the original scope of work. Ultimately, we have also reimbursed you of the exact figure of rupees 437 crores, 437 crore rupees. It has been reimbursed back to you. The original quoted amount was rupees 575 crore rupees, if I'm not wrong. This essential deviation comes from the scope, the difference and the deviation in the scope of work. Additionally, you talked about 3 specific elements, which is materials, labors, and contingencies. All these 3 elements form a part of the scope of work which was to be done by our side and the raw material which was to be procured by your side. And these 3 things essentially try to explain and elaborate the cost expenditure, the expenditure pattern or the cost pattern through which we could sort of bear the cost expenses and then give it back to you as well. Now, in order to provide some legal clarity on the basis of the same, I believe Siddharth is the right person here. So if you may please.
Sure. Before that, I would just like to ask, are there any questions? Because I could see
Yes.
that there exists some apprehension to what Ganesh said. There are any questions, we're more than happy to answer.
Yes, Counsel, I might be wrong, and please correct me if I am, also to the mediators. But I think that we are the ones who invited tender from you. And how it works is the price that you gave us, we reimbursed you the 400 figure that you mentioned. I'm not really aware of the precise figure as of now. But yes, we reimbursed you based on the completed work that you had done, while the original one remains much higher. So I guess there is some factual ambiguity in this regard. I might be wrong. Just please let me know how that worked.
Right. So I'd just like to take this up. So the essential problem surrounding the scope of work, we understand that you have given us a certain responsibility. And I also mentioned earlier that we at ZIL take our work with pride and we ensure that it is in the best interest of everything that work gets executed properly. So if at all there was any deviation in the work that was done, it was not only because we wanted it to be so. We believe that we are diligent and responsible while executing a work. And we believe that the work delays that were caused were also attributed to some fault on part of NDPC. At the same time, we had also granted some reasonable extensions to that as well. Now, that being said, we believe that it is time and we are here to move past the scope of work, any problems that we have surrounding the scope of work, and let's probably discuss solutions as to what can be done to solve this problem. So if Ganesh, if you want to add on to any solutions that you might have in order to resolve this ambiguity that you state there is, and we would be more than grateful. So if there are any proposals from your end, we'll be more than happy to hear.
Yes, Siddharth, I'm very sorry if I did not articulate it correctly. Of course, we look forward to discussing solutions. But my question was with respect to a factual aspect which Gyanesh stated. He said that you paid us an amount of rupees 437.42 crores, while the original contract price, I have the figures now, rupees 575 crores. However, wasn't it the other way around? I mean, we paid you. We don't want to pinpoint any factual mistake that you might have made or we have made, but we just want to clarify it at the outset so as to avoid any ambiguity in the course of the mediation. Of course, solutions are important, Siddharth, and we look forward to that. But just this little clarification could go a long way.
Yes, I'll be very honest. I feel that this sort of an ambiguity exists from both the sides of the party when it comes to the scope of work. And as you already mentioned, we do have to be mindful about the time crunch. and the limited amount of time that we have. And I believe that it's better if we focus that time on discussing and deliberating upon solutions, discussing and deliberating upon proposals about the matters which we are pretty clear on, essentially. So for that, I believe, Madam Mediators, correct me if I'm wrong, I believe it would be fruitful for the session if it gets shifted to the second part of the agenda so that we can put this discussion ahead of this ambiguity, which is essentially hindering the communication between both the parties.
I would like to interject here. I'm very sorry, but I think it's important. I believe, Gyanesh, that the ambiguity is not with respect to the scope of work. Yes, I mean, there is certain vagueness, but the point that we were discussing was purely factual aspect. And I think I have the financial statements in hand and I can state with confidence that we paid you the amount and not the other way around. I mean, it's a very tiny aspect, but still important. But yes, regarding the first agenda itself, I understand the time crunch that we have and your effort to move to the second agenda, but just this one tiny bit of question that I think Sadhil also asked about the interpretation. How do you see it? Please make us see the contract clause in a way that you have. We are ready to understand. We are not being stubborn here, right?
Absolutely, absolutely.
Okay, before Sadil, before you go ahead, can I just provide you with what I inferred from the factual matrix? Just for clarity's sake. As far as I understood from the factual matrix, you were supposed to provide ZIL with payments for work contracted. However, the scope of work itself reduced by 18%. And the issue that ZIL had with this was that resources had already been mobilized. So there were a few overhead costs, I think, that you had to incur, which is what you are seeking compensation with regards to. Because I think the underlying contract was based on NPDC paying ZIL for the scope of work that they were conducting. Am I on the same page with the requesting party? Because I believe this is what you were putting forth as well.
Yes, precisely the point that we paid you and not the other way around. And rest of what you explained, yes, we agree with that. So we can go forward.
Right. Is the responding party on the same page, or are you on a little bit of an impasse?
No, I believe we both are on the same page. Thank you for the clarification, Madam Mediator. And now that we are clear of the facts at the very outset, we would absolutely love to hear about the solutions and the proposals on the very same aspect by the requesting party, obviously.
Great. Let's go ahead then.
Yeah.
Right. So I'm very sorry at the cost of repetition. I'm saying it for the third time in a row now. Before we go into the solutions part, we want to understand how you interpret this contract, because since your counsel has assisted you and you have based the claim of compensation saying that the bill of quantities, is that the right term, the bill of quantities? Yes, the bill of quantities involving the cost, etc. They do not come within the scope of the contract, then what is the scope of the contract for you? I mean, I could ask Sadhil to reiterate all of this, but do we really want to get into legalese? So I spent a lot of time with him understanding the contract law so that I can put it forward in a way that a layman could understand. So if you could again reiterate what phrase are we seeking their perspective on, that could really assist in brainstorming solutions together.
Absolutely.
I'm sorry. Yeah.
The rates stated in the bill of quantities cover all obligations under the contract, including materials, labor, and contingencies, unless stated otherwise. So not only is the clause inclusively mentioning materials, labor, and contingencies, for that matter, it also mentions that this is unless something is stated otherwise. So we would just like to understand your interpretation of the same, so we can keep that in mind while we move forward to discuss solutions.
Right. I'll be glad to take that up. So firstly, I'd like to address Ms. Manya's question on the scope of work and how we interpret the scope of work to be. Now, just to answer that, any infrastructure contract or any contract that takes place, it's not that rigid that there is one particular scope of work and outside that we can't go. There are certain provisions which exist with regard to variation as well, which are also there in the present contract. And I believe that particularly answers your question. Clause 51.1, 52.1, and 52.2 provide for variation terms regarding various situations. However, as Madam Mediator also mentioned, we are not here to dispute whether the terms of the contract were followed or not. And essentially what we are here doing, as this is a pattern that we can see, we are again going back and forth on the aspect relating to the interpretation of the clause. What Ms. Mediator also wanted, I believe, is to move forward with the solutions that we have. So I believe that rather than trying and interpreting and going back and forth on this aspect, we can maybe move forward and find out a way as to how we try to resolve this issue. Will that be okay with the requesting party?
Right, Siddharth. So the purpose I mentioned the contractual clauses and Sadhil quoted them was not to enforce the contract. And I reiterate, we do not wish to be stubborn in regards to the enforcement of the contract. Since you asked us to propose some solutions and we could brainstorm some together later, we wanted to understand that if you are claiming compensation, how do you see that the extra expenditure that you occurred, given that the cost of things changed, given that you required more raw material, how do you see the scope of the work getting expanded? Because if we could get insights on the same, then we could propose some solutions accordingly. Because if there is vagueness as to how you see it, we are not saying how the contract says it, but how you see it. Does that clarify?
Sorry, Madam Mediators, I believe that despite trying our level best, we have not been able to move forward in this mediation session. So I believe this calls for a caucus or a private session where we can have a one-to-one word with the mediators and discuss this issue and how to move this.
Yeah, sure, you can.
Thank you.
Sure.
Can the host please create a breakout room?
Supervisors, please.
Yes, wait. Please join the room.
Yes, can we speak?
I do need to mention, though, that this is also confidential. We won't be telling them anything unless you expressly and explicitly allow us to do so.
Yes, right. Madam Mediator, to first off put my concerns, I believe that the mediation session has completely hit an impasse.
Right.
What we essentially thought why we are coming here in this session was not for an interpretation of contracts, because interpretation of contracts, documentation, legal arguments have already been taken place in a court of law. What we felt and the viewpoint with which we came in this mediation session to discuss multiple aspects wherein the payment has not been made. However, when it comes to the interpretation of the scope of work, we have tried clarifying our level best. Now, when it comes to insurance and when it comes to the other factor, the concreting part, that is where the other party has visibly faltered. And I believe that is the very core reason why we are not shifting towards the majority or the points which we should focus more about. So please provide us a solution regarding the same. And I think Siddharth also has to add a few things to it.
So I believe that, as Ganesh very correctly pointed out, we've had multiple rounds of arbitration and litigation wherein we've already conducted this exercise of interpretation. And I believe that the compensation aspect that we are asking for, it's not only restricted to the scope of work. As Ganesh mentioned, it is also inclusive of the other two agendas that we have on the table. That is firstly the concreting qualities, and thirdly the insurance aspect. So that is also one of the reasons why we wanted to discuss those agendas first, because we knew that given the arbitration and litigation that we have had, there is a slight apprehension with the requesting party regarding the interpretation clause in the contract. That is not to say that we have faulted in any interpretation. Of course, there exists provisions pertaining to variation, as I also mentioned before. However, we would not like to use this mediation session to delve into the interpretation of statutes. Rather, we would like to explore solutions. Otherwise, the relationship between the parties, as Ganesh wanted to preserve, would not sustain. So that's not something that we would want, right, Ganesh?
Yes, and more importantly, I believe that we have come here with an absolutely open mind. We are okay to understanding their position. We are okay to understanding where they are coming from. We're also okay to exploring other ways, such as payment in cash, payment in kind. We're also okay to taking reductions in multiple aspects, and we have some really creative solutions for this session. And I believe that this to and fro discussion is really not going in the right direction towards, solving the problem at hand.
Yes, we can see that. I have a question. Could you clarify that?
Sure.
How did the project adjustment affect your ability to meet the contractual expectations?
The project adjustment in relation to all the 3 points?
Yeah.
So if I have to summarize it up really quickly, when it comes to the insurance, they started adding different heads under the insurance sector unilaterally. When it comes to the scope of work, they essentially paid us and we had to pay them back. We paid them back a certain sum of money. There was a deviation of 18%, which they did not accommodate. For the concreting part, there was a stipulated amount. We exceeded that amount due to certain geographical problems, because of which we demanded some extra payment. That too did not happen and they were not ready to accommodate for the same as well. So these are the broad issues which we have essentially.
Okay, I have a clarification to make with you.
Yeah.
So as of now, you are still holding that the payment was to be made from your side to them in with regard to the 18% deviation, because as far as I'm clear on the factual matrix, I believe that NPDC was to make ZIL payments, and the 18% reduction in scope of work was a problem because you had already incurred costs for the overheads and related expenses for the 18%. And that is what you are asking compensation with regards to, correct?
And I just like to add, and they also want reimbursement for this concreting part as they have exceeded and they have spent on that also. Am I right?
Yes, these two are two different heads, but yes.
Yeah. So what led you to that exceed this concreting part? So sorry, I just repeated. So what factors?
Marcus, before we get into that, maybe we could just like hyper focus on the issue at hand before we can open that, because I think that's a completely new issue.
Right.
Could we just
yes.
with this?
Right. So, Madam Mediator, Ms. Taruni, I would first like to address your question. Your question regarding the factual matrix. I believe that what Ganesh was trying to do is talk about reimbursement of the money that has taken place. Since he's so emotionally invested in this project, I believe there are certain mistakes which he makes regarding numbers, and that's exactly why I am here for. So the purpose of what he said was regarding the deviation and subsequently how the terms were altered. Right? That's what he wanted to mention. And regarding Ms. Marcus's question, I would just like to say that there were certain adverse geological conditions which took place, which led us to do more concreting, which led us to an increase in the concreting quantities. And that's what we did. As I also mentioned previously, ZIL takes its projects very seriously, and it does everything to ensure that the project is completed in the best manner possible. Right, Ganesh?
Absolutely correct. And I understand.
Please complete it.
I understand that I might have misplaced the words, but that purely is because of this emotionally charged session, which I was not really expecting, to be very honest. But I understand. I'm so sorry. I hope Siddharth has made it clear for everybody here.
So my question is, were the cost was communicated in advance that you are exceeding this concreting cost?
Yes.
Was this communicated to them?
Yes, we have intimated them multiple times.
So prior to beginning the concreting cost, you have informed them earlier?
No. The cost incurred were after completing the projects, because once we started the concreting process, we realized, okay, this is going to take a lot more than we expected. So we, in order to complete the project first, we sort of incurred those expenses, and then now we are asking for a reimbursement of the same.
Okay, thank you so much. I think we are very close to the time limit of this private caucus. Anything you want to keep confidential so that we do not reveal to the requesting party?
Before that, I would just like to say something. In terms of your concerns about how we're not moving forward, I understand. But I am afraid that even the other two agendas are very contract based. So while you can't escape talking about the contract, we could possibly segue them into moving on to the next agenda.
But we can absolutely talk about contracts there as well. We do not have a problem with that. We just want to be don't want to be stuck up at a particular place.
It's not that we don't want to discuss contracts. It's just that we don't want to and fro where we're blaming each other, right? We want
I
more.
understand.
Right. Thank you so much, Madam Mediator. And regarding Ms. Marcus's question, I would just like to say that anything that we've discussed in this caucus, everything is to be kept confidential. We do not want anything that should be revealed to the other party. If that is
Okay, thank you so much.
Thank
Yeah,
you.
yeah, we will do that for you.
Thank you.
Thank you.
Welcome back, requesting party. So we do have some developments for you. We've noticed that there's been a little bit of back and forth, particularly with regards to the interpretation of scope of work. And that is not something that is going to leave the two of you. I can assure you that in all of your future sessions, it's going to come up. But as of now, I would suggest both me and Marcus as mediators think that it would be more productive for this session in general if we were to move on to the next agenda, because that too concerns the contract. And I know that the first issue is pressing and fundamental, but in the interests of having a productive discussion, I would say let's move on to the second point.
Of course, Madam Mediator, if that's what the requesting party wants. However, I believe that Gyanesh asked us about, I think Gyanesh and Siddharth both requested us to propose some solutions with respect to the first agenda. And actually, we do have some, and that is why we were focusing on their understanding of the clause. So if it is amenable to the mediators and the responding party, we can very briefly propose the solution. We are flexible either way.
What I believe is that once we are clear of the ambiguities in relation to the scope of work, and there has been a lot of to and fro right now, so there exists a lot of confusion. I believe that in the future sessions, when we take this up again, we can, of course, come back to the solutions right back at it. Right. I hope that's okay, Madam Mediator.
That's okay with us. Is it okay with the requesting party if you
Yeah,
want?
please.
Yes, it's okay from our side as well.
Okay, then you can segue quickly into the overbreak payments and the concerns around it.
Yes, thank you, Madam Mediators. So firstly, we would want to talk about the insurance aspect of the thing. Now, I'll be very honest, this was something which I was not expecting, because there has been a lot of information overload. There has been a lot of confusion. There has been a lot of ambiguity regarding contractual clauses. It is my humble request that we have prepared a simple chart, or essentially a simple document, which explains everything, at least from our perspective. And with the direction of Madam Mediators and also the administration, we would like to sort of present it while we also present our case for mostly for about 30 to 45 seconds, if that is all right. Sure.
If we can maybe send the file to the digital administrators,
Yeah,
and
we are
maybe you
doing
can
that.
present it, we'll be more than grateful.
Yeah, we are doing it right now.
Yes, yes.
Now, for the time being, when Siddharth is presenting those contractual sort of clauses and then all the legal technicalities, I would want to delve into the matter of insurance. What happened essentially factually with insurance was that there was certain stipulated terms which are definitive parameters when it comes to the insurance clause. Now, for 9 months, there was no specific objection or no specific change which was made in that insurance clause, and we were okay with that. No objections were also raised by the side of NDPC in that as well. However, 9 months later, what happened was that a different clause of an earthquake risk coverage was added. It did take us by surprise, but we realized that it's okay. In order to foster good faith between the parties and in order to foster this relationship further, what we did was we moved ahead with that earthquake coverage. We were absolutely okay with that. However, later on, they also went on to unilaterally impose another coverage termed as terrorism coverage. That was the point when we realized that essentially, I believe that there is an attempt to shift the burden of having insurance onto our shoulders, and we got a little bit apprehensive. So what we feel here right now is that the term or the entirety of the insurance sector or the insurance specific clause was unjustly added towards us. And what we are seeking out here as an immediate proposal is a compensation for that excessive terrorism insurance coverage which was added and which we had to incur. We are okay with the earthquake risks, earthquake risk point. However, we only have concern in relation to the adding of the terrorism factor and would want compensation for the same. Additionally, we would also want to ask the requesting party or the NDPC if they have any potential solutions for to prevent any future happenings of certain events like this or not? We would love to get their views as well. Meanwhile, the screen has been presented. So there, I believe the contractual elements can very well be explained, hopefully very clearly this time by Siddharth, which leads to no ambiguity in this session anymore. Siddharth.
Right. So just talking about the insurance aspect, which is given in point 2, it talks about we've extracted 2 broad clauses from the annexure that was given to us. That is employers' risks and insurance, which broadly covers 20.4, 21, and broadly clause 21 of the contract. Now, what the insurance clause in this contract does essentially is provide some sort of protection, right? So we have discussed, and the current state involves, and during the developments that happened between both the parties, firstly, there was an earthquake risk policy. If I'm not wrong, the earthquake risk policy was first implemented, and secondly, we had a problem with the terrorism risk policy. Now, I would like to direct your attention to the second clause, and I've also mentioned a redacted version of the second clause, which is exclusions under clause 21.4 include no obligation to insure against risks listed in clause 20.4, including terrorism. Now, the broad idea behind this is that, firstly, since you are the owners of the project, we believe that we as purely an infrastructure and construction, we are here to assist you in developing the project, and we don't believe that we should bear the burden of insurance or everything, right, Ganesh?
Yes, so there was a lot of legality out there. Hopefully that clarifies the contractual aspect of insurance. But again, my concern here, or something that I really want to address here, is the potential way forward. And I've already stated that I would be extremely okay if the NDPC could provide me first compensation for the same, and secondly, to tell me about a specific way through which we can avert the situation later on.
So parties, I just like to summarize what the responding party has stated. Like earthquake coverage policy was added earlier, and the responding party was okay with that. But the unilaterally addition of terrorism risk, so they want reimbursement for that. Am I right? Co-mediator, would you like to add anything to that?
No, Marcus. Thank you. Thank you for summarizing.
If we may.
Yes, you can.
All right. So, firstly, there remains some ambiguities with respect to the risks regarding the employer that are given in the contract. However, the risks regarding the contractor are not very specifically mentioned, and there is some ambiguity there. However, regardless of that, we understand that we don't want to get caught up in how the contract has been drafted. We are willing to give compensation. However, we have some terms and conditions regarding that as well.
Right. And this takes us back to the solutions that we had in mind before. So if Sadil, you could elaborate on that.
Absolutely. What we had in mind was a performance-based incentive solution, where if you could possibly guide us as to a particular timeline of when the project could be completed. Because if I'm not mistaken, the original timeline was for the project to end in 2019.
It was 2019, and then we extended it to 2023. And now we are here today in this mediation.
Yes, absolutely. And that is not to place blame on anyone.
Right.
That is not to say that anyone has been negligent or anything. The fact remains that while the project was supposed to be completed in 2019, we sit here in 2025 and it remains incomplete. So for us, the priority remains, and we hope that it's the same for you, that the project is completed. So if you can give us some guidance regarding when it will be completed.
If I may add before Siddharth and Ganesh, you could take that up. Timeline here remains important for us, and why we propose this. I mean, I am the executive chief, and I must, address the economic interests of NPDC, and that is why we are kind of hesitant regarding a full-fledged compensation. However, we are amenable to a partial compensation in that regard, as Sadil mentioned, that will be contingent on a timely completion of the project, because given the nature of this project, given the sustainability it offers, NDPC does not want to keep it in hanging for any longer now.
Yes.
Uh,
Thank you so much for the solutions that were proposed. I just had one clarification. Is the performance-based solutions purely related to the insurance point, or it's like a general solution that you are proposing?
Okay, so I think that you have demanded compensation with respect to all the three agendas, right?
Yeah, but right now we are talking about insurance. So
Yeah.
compensation was essentially for the insurance part.
Right. So, given that you have demanded compensation for all of the three, I think the compensation can be adjusted, subtracted, added. Is that right? Can that be done?
Absolutely, yeah.
Siddharth, I would like some inputs from you in that regard, just to confirm.
So I'm so sorry. So this compensation, we are talking about the insurance compensation right now, right? Because then we would talk about the adjustments accordingly. That's why I just needed that.
We can stick to insurance.
Okay, great. So I believe that is there a specific limit which you want to stick to when it comes to a compensation? For instance, let's say a limit of 70% or 80%. Is there a specific limit in your mind?
I do not think that I have told Sadhil about any limit as of now, because we really were, making our answers contingent on how you see the contract. But since, given the paucity of time, the discussion could not be furthered. I think that a limit could be set, whatever is mutually agreeable to both the parties. Any proposals from you are welcome.
So, firstly, let's mutually discuss the limits, obviously, at first. But I think, especially given the session, it's been 1.5 hours, but we've been sticking in relation to different clauses of the contract. So I believe in the holistic nature and for the benefit of all the parties in the future future projects to come in relation to the same contract. What we propose is certain amendments to be made to these three clauses. Now, these amendments I would list down in a categorical manner. Firstly, in terms of insurance, what we propose essentially here is that there should be a consolidated emergency fund. Now, this consolidated emergency fund would lead to a removal of the insurance clause from the contract. And in this consolidated emergency fund, both the parties are going to chip in funds. However, the ratio would be 60:40. Purely as Siddharth already has mentioned, because of the reason that being sort of the owner and having a more share of responsibility, we believe it's better if you could chip in more amount of money in this project. However, we are not letting your interests go by saying that you should give a 60-40 share. With that, we are giving you a complete discretion on determining the parameters of usage of this consolidated emergency fund, which means that if in case you feel that it should be used for let's say earthquake expenses, or if it has to be used for certain unprecedented expenses such as let's say and any insurance expenses which we have already mentioned in the contract, those can be included after discussion, but the discretion completely remains with you. I hope this makes sense before I move on to the second amendment.
Absolutely, we agree that this is something that can be established in the future. I don't think that we have an issue with that. Our only question related to this is with respect to the retrospectivity of this, because while this is something that we can discuss across mediation sessions and establish in the future, the situation at hand in particular, I don't really see how that will be resolved by virtue of this clause being added in the future.
So I believe the number was to be established or reached into conclusion by both the parties, as already stated, obviously, by Manya. So obviously, we as because we were at the receiving end, we would want 100% payment in cash. But obviously, in order to maintain this strategic collaborative partnership, what we essentially propose is, and tell me if you're on board or not, is a 50% payment purely in cash and a 50% payment in kind. Now, when I say payment in kind, it does not necessarily mean that you have to give something for it. Obviously, we are very much up. We know the presence of NDPC in the market. We know the infrastructure they have, and we know they have been in this market since a lot of time and the offers they get, especially with the governmental support they have. So when we talk about the kind, it can come in terms of either leasing or giving us full access or control of the machines, which you have for our future projects, or giving us a sort of prioritization when it comes to the next deals or essentially the next government projects which you undertake, so that in the competitive bidding process, we get prioritization and we again get to work together and foster this collaborative effort together. So in order to summarize the offer, it's essentially 50% cash and 50% in kind as elaborated by me right now.
Ganesh, if you could just clarify. So the very last aspect is sort of a right of first refusal, right of first offer situation that will come to you guys.
Right.
Siddharth, I think this
Yes.
is technically, yeah.
Yes, it is. So it's actually right of first offer. It's a ROFO clause that we propose to include in the contract. And basically, I believe that he has already talked about the Consolidated Emergency Fund, where they have certain rights and we also have certain rights. So if all of that can be incorporated in the contract, we could read that very well.
Okay. Requesting party?
Yes, thank you so much, Ganesh, for these wonderful solutions. And I believe that you guys have really brainstormed, right? So, yes, we can discuss the 50-50 cash and kind arrangement if I got it correctly. But just as one preliminary question, since you mentioned about discussing numbers, so I am assuming you agreed upon the contingency of timely completion of the project, since that was the condition of the proposal that we put forward in this mediation. If you could agree. If
I understand. So I believe that timely completion is something which is your concern, and I truly understand because it's my concern as well, because even our reputation is right now at stake. So I think what we can plan and try to do here is, why don't we link the 50% cash component in relation to, let's say, as you already mentioned, performance-based incentive, or let's say in the form of a bonus. So for that to happen, what I would propose and what I would suggest here is that you would pay a partial amount of cash as and when we complete the milestones. If we complete it on time, if we complete it effectively, we get it. If we don't, then we don't. I believe this is a very fair share ask for the cash component, and I believe the kind component can obviously, it's a long-term thing, but I believe it can be done by you as well. Siddharth, if you could just elaborate on the first part a bit.
Just to add to that, maybe the 50% component can be split into two components based on performance. So currently you give us a certain percentage of the money, and subsequent to our completion of the project, which I'm sure we are working on towards completing in this year itself, you can give us the remaining amount. So I would like to hear your thoughts on this.
Would the party like me to summarize before
Yes,
that?
that would be great. That would be great.
Okay, so I think what the responding party is proposing is that you split the payments into 50% cash, out of which part of it is contingent on performance and completion, and part of it will be paid as is. And the remaining 50% will be in kind, which can be in the form of leasing, access to machinery, and a ROFO agreement.
And I just like to add, prioritizing on the next deal also, they said it.
we may, Madam Mediator.
Please go ahead.
From what we understand, the basis for this is that there still remains some ambiguity in the contract itself, right? And for that reason, and for our own sake, because we want the timely completion of the project, we believe that we can find some wiggle room in that respect, where if instead of there only being 25% of the compensation being contingent on completion of the project, we believe that that may be worked out a little bit differently. Additionally, with respect to the payment in kind, it would put us in a tight economic situation, because again, there is ambiguity in the contract itself. So
If I may take that up, since that involves economic concerns of NPDC. So we believe that the contract, as Sadhil mentioned, remained ambiguous with respect to whether or not the contractor can be made to pay the insurance regarding terrorism. However, when you ask for 50% compensation in kind, it kind of reinforces the notion that we are wrong in this regard, and I don't think that it's a win-lose situation in the mediation. That is why we came halfway to you, asking for making it contingent on the timely completion of the project, so that we both have something to gain. We gain the timely completion of the project, and you gain the compensation that you want. Of course, 50-50 cash kind arrangement, we are amenable to that. However, we are little hesitant in not making the kind part of the percentage that you're asking for contingent on timely completion?
Manya, first of all, thank you so much again. I feel finally we are progressing forward in the ways of solutions. And I truly appreciate, I understand you come from NDPC, but I would like to reaffirm the fact that it's not just your project or my project, it's our project. And trust me when I say this, we are trying our level best to complete it in as less time as possible. Also, just providing a little bit clarification on the 25-25 ratio. We are not linking or attaching the first 25 or merely the 25% on the basis of completion. Rather, we are linking the 75% depending upon the completion of the project, and we are wanting the 25% upfront. Why? I'll just explain it to you how. The second 25% would be given to us on the basis of a bonus based on achieving milestones and achieving them perfectly. The next 50% addresses your second concern. What we are wanting is not an immediate payment in kind. All we are looking for is a support from your side. Because there has been I believe that there has been a clear contractual violation, if I'm not wrong.
Right.
Siddharth.
So just delving into some contracts and then possibly going to the solutions, I would just like to say that any solution that we are proposing thus far does not put any of us parties to be in a wrongful position. Ms. Manya, I think you have that slight apprehension, and it is totally understandable. But we are not here to accuse you of anything. Rather, we are here working on developing that relationship. So any issues relating to interpretation, and I believe Mr. Sadil has also mentioned that there is a lot of ambiguity in the contract, almost repeatedly. So what we can do in this situation is maybe both of us sit down and then discuss the project and then amend the contract, discussing the solutions that we have through this mediation and the subsequent mediations. Probably that can be the first solution. If Ganesh, you would want to expand on it.
Yes. So in addition to the funds and in addition to the 50-50 cash in kind, I believe that was the subhead of the part of the first amendment.
Right.
That was the first amendment I was proposing, that let's just, if there are so many ambiguities in the insurance part, we are going to scrap that. And then I think there were two more amendments, Siddharth.
Yes. So I just want to add that what we wanted here was terrorism not be included as one of the policies, the risk that we want to undertake. Because firstly, it is, as I mentioned earlier as well, it is not our onus to do so. Still, since we come with an open heart and an open mind, we want that earthquake and some sort of risk we imposed, some sort of risk we can take it up. But then the solutions that were suggested by my client Ganesh is in the joint emergency fund. So what that does essentially is give you the discretion to put anything and everything into the joint emergency fund. So I believe that solves everything. If that can be incorporated into the amended contract, where we both sit down, we resolve our differences, and then we amend the terms of the contract, then maybe we can carry on this commercial relationship forward. So I would like to hear your thoughts on this.
I just like to summarize, as you said that you want 25%, keeping 25% upfront, and by linking 75% on the basis of bonus. And what do you mean by payment in kind? You want basically support from them, and you don't want terrorism risk that it's included in insurance, and you just want a joint emergency fund, and you both will decide by sitting down. Am I right?
Yes, just to clarify, I know this is a four-pronged thing, so it gets confusing at times. We would be sending a written
Yes,
form of this
we
as
will
well
definitely do that
very soon to clarify it very easily. But the first 25% is an upfront payment in cash. Tell me whenever you want clarifications. The second 25% payment is purely based to bonus and us receiving the milestones. The rest and the remainder of the 50% should be paid in kind. Now, this kind can either be in terms of machines or having the clauses, as already very much elaborated by Madam Mediator before. The consolidated fund forms a part of this umbrella, where we are suggesting that amendment to be made in the contract itself. And I believe this is a different sect on these two things. They essentially form a part of two different plates. I hope I'm clear. Please let me know if there are any concerns or clarifications required by my side.
So to put it into perspective, your 25-25-50 split is a more short-term, immediate sort of move. And your consolidated emergency fund is a long-term amendment to the contract that is proposed.
Yes.
Right.
Okay. Requesting party, please go ahead.
Gyanesh, just to clarify, I'm sorry I'm making you repeat so many times, but I think it's a little hard for me to grasp it in the first go. So the 50% will be in kind. The 25% out of the other 50% will be paid right now, and the other 25% will be made contingent on the conditions that we only proposed, right? Okay. So can we tweak the numbers a little bit? Because the calculations that I had in mind, the compensation that you are asking for, I mean, it is certainly a very creative solution. You know, this 25, 25, 50, very engaging. But I would really like to know if you're open to tweaking the numbers a little bit.
Sure thing. Can you tell us like which
Yes.
part do you want the tweakings to be in?
So we truly anticipate that our support is more valuable to you than any compensation whatsoever. I mean, money remains important. We are ready to extend support for you. And I think I discussed that with Sadil as well. He agrees that, yes, we can. I mean, your corporation is such talented people are there. We are ready for that. However, we are not ready to part with our money so quickly, and especially the 25% part, which is not based on any contingency. Why we in the first place propose timely completion? Because as I mentioned, and again, I'm not pointing fingers, but it has been delayed by so many years. So if the entirety of that 25-25 split could be added to one and made a 50% completely contingent on the timely completion of the project, the timeline could be discussed by the councils before the next mediation session, given the paucity of time. But just if the 25-25 could be merged.
Um, I'll just give a brief background before actually moving towards the solution. What we believe here is that we have always focused on fostering collaborative approaches and fostering the relationship which already exists between the parties. However, this does not disapprove of the fact that we have been wronged, and we have been wronged multiple times. And I understand that parting away with your money is a very big deal and something that's really painful to do. But we have had to do that since a period of 2 years now. So honestly, it's a bit uh, overwhelming to hear that response that you're not ready to give anything upfront, despite, making certain contractual annulments, despite, all of those things. However, again, showing good faith, I also understand that this is very, very important. I also understand that this collaboration should exist, and money obviously comes and goes. So what I'm saying is that one point of aspect which we failed to recognize and address in this situation was the concreting factor. The concreting factor wherein we had to inculcate an additional 10% of cost, which made it to 60%. Of that, I mean, I don't want to now again go into the contractual learnings because unforeseeable circumstances were given there. Something else or the other would be disputed. So let's not go there. Let us just I would want to simply wrap both of these issues, which means that the excessive amount for additional concreting and the insurance part should be paid as 30% upfront. I want to remind you that this 30% is not specifically for the terrorism expenses. We are already letting go of the earthquake risks. We are already preparing a consolidated fund with a 40% investment in it. And we are also letting go of the fact of that 10% increase, which was, if I have to put it in specific numbers, because now we are talking about numbers.
Right.
You
want me to do it?
Siddharth, can you just?
Yeah. So essentially, according to the BOQ, what we were to do is 47,450 cubic meters. But what the work that was actually done by us was 79,075 cubic meter, which is essentially an extra of 66% of the work that was agreed upon earlier. So what Ganesh's solution does is that it is a two-pronged solution solving both the problems at once. Ganesh?
Yes. So I'm ready to let go of a lot of economic incentives. I'm ready to let go of a lot of economic sort of, lucrative opportunities. I have already done that in order to sustain the relationship and also ensuring that this project gets completed on time. So I am ready to combine both of these economic parts into 30% of an upfront payment and 20% of a bonus link payment, and the rest of it remaining the same.
Thank you, Ganesh. Thank you very much, Siddharth. I mean, I see this 10 minutes remaining message popping up, so I will wrap it up quickly. I think that we should not use words like wronged or annulments during mediation, because it's really hurtful to hear that when nothing of that sort has been established. I mean, Sadhil also mentioned that the contract is vague, and when it's vague, blame game is not the right way to go. Regardless, I believe that you are merging the solutions for agenda 2 and 3. Very intriguing. Sadhil, if you could take that up.
Absolutely. I know that we discussed that we didn't want to go into the contract again. However, I believe that it is an imperative part of the discussion that we must have in relation to the second agenda.
Especially when we have been blamed of wronging you in that
Yes.
sense. So I think a reference to contract is important here.
Exactly. So
Yes.
the point remains that clause 12.2 of the contract refers to unforeseen physical conditions.
Right.
Our only assertion in this regard is if it can be proven from your end that the situation that you ran into was truly unforeseen, and if it was truly due to GAOs, if that can be established, we will be willing to address the compensation question considering the paucity of time at the next mediation. However, that is something that we must establish considering it both parties have agreed to this contract. Regardless of the vagueness that we addressed from both sides, this is a contract that both parties have agreed to. So this element of wrong that is being addressed.
No offense, no offense.
Yeah, absolutely.
Yes. I'm so sorry if
No
any of the statements got heard. I know I used the word wrong one time, but now it has been used 4 times by the other party, so I understand. I'm so sorry. That was
And
not
no
my
offense, Ganesh. We just wanted to
Absolutely.
This
establish
mediation
trust.
session has been going on since 2 hours, and I'm literally very emotionally charged. Given the sort of haircuts that I've been taking and the solution that I've been proposing at this moment, when it comes to proving whether it really happened due to certain geological problems or not, I would believe appointing a third-party evaluator would solve the problem. And I don't think it's going to take a lot of time. It would probably take 6 to 7 days, I believe.
Yeah.
6 to 7 days would sort it. And I think, Siddharth, can you just explain about this a little bit?
There was one more point that I wish to discuss. So there was a certain level of discount that we have given, that we had offered regarding the whole situation surrounding this concreting quantity. So we are willing to propose a solution. What Ganesh has essentially done is he has proposed a solution wherein we are not exactly going into the terms of the discount itself, which is another agenda that we had in mind. So the proposed solution essentially holistically captures both 2 and 3, while also providing you certain concessions, while also resolving us of our whole situation and as you mentioned, the ambiguity in the contract. So if we could have your thoughts on that, please.
Okay. So I might have understood it incorrectly. Please correct me if I'm wrong. So when you ask for combining the compensation under Agenda 2 and Agenda 3, that is the overheads and the insurance, I believe, there is an inherent assumption that we are liable to pay compensation for the overheads. I mean, we can tweak the numbers as we want, but I don't know how to make sense of this underlying assumption when nothing has been discussed of that sort yet. And I see that there are 5 minutes left of now. So I do not think that we can get into the legal niceties unless the other party has something important to add. So I would like to ask the mediators and of course after Sadhil.
Absolutely. And we say this with no intention of trying to instigate each other. We recognize that both parties are sitting at the table together, and that is a beautiful gesture from you as well. All we say is that in principle, we have agreed to the fact that some compensation may be paid as long as it is contingent on the fact that the project is timely completed, as you mentioned, maybe by the end of this year. I believe we have made substantial progress in that regard. I believe the exact details regarding the compensation to be paid can be understood and realized at a later date in a later mediation session.
Let's leave that to the council, Ganesh. And if I may ask the mediators to summarize and conclude the mediation, of course, after the responding party, if they had something to add. That's all from our side.
Yes, I'm really glad that despite having, I think, 2-3 minutes, having ambiguities and, having differences to and fro here and there, we are able to reach up at least to in principally agree to something. I feel that is also a victory for both the parties here, because we get the compensation and we anyway would try to make sure that the completion takes place really fast and effectively. So that's not going to be compromised. I just have one point to add is that if the only concern is the validity of our claims, I'm sure a third-party evaluator would be, we are honest. We are sure whatever claims that we are making, whatever figures that we are putting are completely true to its fullest sense. And it can be evaluated by a third-party evaluator or an evaluator of your choice as well. So that just add a little bit and let's
Right.
just wrap this up.
Yeah, and now since there are a lot of things being discussed, I would request the mediator to kindly summarize what all has been discussed, and then we can maybe close this session.
Yeah,
And later on, we can discuss everything, since in principle, certain things have been agreed to, and we can come prepared and then have like a proper discussion on everything.
most certainly.
Thank you so much.
Thank you so much.
Right.
Yeah, you can begin with it. I just said after that.
Okay, thank you. So there were a lot of proposals that the table saw. I'm just going to focus on the main one. I think the main conversation that took place today was with respect to the split compensation. I think in principle, both parties are willing to look into that. Exactly what the compensation is for is yet to be hashed out in the next session. And also the numerical aspect of the compensation needs to be decided and demarcated further as well. Apart from that, I think the requesting party's motive in terms of their claims is fueled from the completion of the project on time, and the responding party has compensation concerns with respect directly to the contract. I think this is fundamentally what took place in today's session. And Marcus, if you want to add things and just close it, make it nice and holistic. Thank you.
Yes, I just like to add, like responding party said that they will appoint a person, a neutral person that will review these calculations after that. And that's the things I like to add. And I just like to congratulate and thank you both the parties for showing your willingness, openness that you have shown in this session. And it's said that every story has an ending, but this session will prove to be a beautiful beginning for the upcoming session. And I can see the optimism of both the parties that they showed. So thank you so much from both the parties. And we will coordinate the next session by concerning both of you. Now I pass the floor to the parties so that they can also speak a few words. Thank you so much.
Thank you so much, Madam Mediator, for collectively summarizing every issue. We just have one request. If maybe a note can be shared regarding every agenda point that we had, that would be of great help in the next session, so that both the parties can in fact come prepared. Thank you so much for attending this session. Thank you so much for discussing everything. And I believe Ganesh has something to say.
Yes. No, I really I don't have anything else to add. I think we have talked about the kind payment, the support, everything else has been talked about. And I feel it can very well be talked about in the sessions to come as well. I'm just really proud and happy of the developments that both of us as parties have made today. And I'm looking forward to solving this difference as fast as possible in the sessions to come. Having faith in each other. Thank you so much.
Thank you so much.
Okay, so I believe the time's up. I won't take much time. We also want to thank the mediators, and we don't have much to add to what Siddharth and Ganesh said. Thank you.
Thank you so much, teams. The time is really up right now. For the part of the process, we would request the judges to start the scoring first. We'll take the judges to the breakout room for this purpose of scoring. And then we would return to the main session for the feedback session. The court master may please send the judges to the breakout room.
Shilpa ma'am, I request you to please join the breakout room.
But where is the breakout room? Can you tell me? I've
Ma'am, a pop-out must have appeared on your
no,
screen.
it hasn't come on my screen.
Okay, I'll check with the court master once.
Okay, please.
Ma'am, can we request you to rejoin the session once, please?
So.
Seems some difficulty.
Ma'am, I'm assigning you the breakout room. You'll get a message right now.
Sure.
Hello, if the OC could confirm the same if we have to wait for the feedback.
Yeah, you have to wait for the feedback.
Okay, and how long will it take estimatedly?
After the scoring by the judges.
All right, thank you.
Okay. Actually, judges are in the breakout room and your scorings are going on. So you all have to wait for the feedback. Okay?
All right, thank you so much.
Okay.
Dear participants, please switch on your camera. We'll start with the feedback session.
So we're supposed to give feedback, right?
Yes, ma'am.
Okay, so can I just start then? So I think both the teams did a very good job. Congratulations to both of you. As I said in the breakout room that, I was thinking of my law school days and I was not a patch near you all. So good, keep it up. I really have no comments as such to tell you how you can be better or anything. I think perhaps the others may have. My only comment to the other team is that perhaps in mediation, it helps to be a little less aggressive. That's the only point I would make. As far as mediators are concerned, I think, again, you both did a very good job. So I really cannot say what to do or what not to do. You were absolutely brilliant. So congratulations and keep it up. And I'll hand over to the others. Shilpa or whoever wants to give comments, please go ahead.
Ma'am, you're muted, Shilpa ma'am.
Right. I'll take it forward from Mamta. I really echo the same sentiments. that you both are winners. You were so good. And it's amazing how at this young age you're able to articulate everything so well. The whole intent of mediation, it permeated the whole process. You could feel it all the time. Also, the fact that you were mentioning it, and the fact that you were actually implementing it. So that was very good. But yes, the responding party did use the word wrong a few times, which is a little bit out of place in a mediation. So just a little point over there. And the mediators, they were very much in control of the whole proceedings, and they were capturing the essence of it very well. So heartiest congratulations to all of you. I think you were brilliant. Thank you.
Thank you, ma'am.
Right. I echo the earlier judges, we are actually enjoying the energy of our youth in mediation just now. You guys did a great job, both groups, both mediators, and we can see the spirit of mediation in you. We hope that you will go forward and you have potential in this. This is all about win-win. Even if you're not the first one, but you still win because you have the knowledge, you learn a lot of things here. And I guess that's all from me. Thank you.
Thank you so much, fellow judges. And then I support what you had said. Very professional. I like the way you communicated your points really well. For each side, you were very when you started communicating your positions. Of course, the interest also. It was very clear, and when you moved, and I liked how the conversation was really forward looking, and that's really the essence of negotiating successfully and mediating successfully, is moving the conversation forward. You did not get stuck, although there was in our conversation in the breakout, I did mention that there was a moment that you got stuck because there was one interest that wasn't being addressed. No, it was very important to one party, and we should always look at that, because if there's one, I mean, the other interests are being addressed, so it was moving forward, but then it was again flowing back because there was something left behind. So and we have to be mindful of that agreements cannot move forward if all of the interests are not being addressed. If it does move forward, then it could be half-hearted and it might not really get resolved at the end. But yeah, congratulations. I really enjoyed listening to all of you. The mediators, you were so great in summarizing. You took control, you took charge of the process. I just wanted to know the feeling of the requesting party, because we had a private session. So we had a private session with ZIL, the responding party. How did the requesting party feel that you did not have a private caucus? I just wanted to, if it was, because we just have to be mindful of those tiny things, right? That would, make sure that there is balance, in terms of attention. May I know, Manya and Sajid, yes. How did you feel that you did not have an opportunity for a private caucus?
Yes, ma'am. Thank you for bringing that up. I mean, we were also discussing if we should call for a caucus, but I think that there was time crunch. And for us, addressing concerns in private, I mean, of course, there was a deadlock which could not be furthered, but we could anticipate that the other party, of course, was not comfortable in discussing this, and the reason might be beyond ambiguity. So we really did not want to push them further and waste more time in, this back and forth allegations and understanding. Of course, we tried discussing that when the caucus will end, we will propose a solution, which I think Ganesh also recommended. However, that attempt was stalled. So I think we moved on to the insurance part.
Right.
It was fine that we did not. I think
Okay.
management mattered more.
Additionally, we felt that we could get more out of interacting with the the responding party than we would maybe in a private session with the mediators. We felt that we had a lot to cover, and the more interaction we had with them, the more that information asymmetry could be taken away, and we could actually come to an agreement. And I believe we made a lot of progress in that regard. So
Right.
Yeah. And that's wonderful to hear. One of the things that I asked Iram when we were in the breakout is, how much training did you get? Because you were also good. I mean, from me watching you guys, I thought you had training. So I was like asking, how many hours did you have training? So
No,
congratulations. So
no.
congratulations, all of you. It's coming out naturally. But maybe just one point for me to leave you with this. I mean, working as a mediator, one of the things that we always tell our mediators is it's the mediation process is not just a problem solving process. It's an opportunity to bring people together and work together. No, it's an opportunity for the parties to work together towards a solution. Because if you're just focused on the solution, then you're just left with that. But if you focus on the working together part, then all of the magic of mediation can potentially happen. So congratulations and good job.
Yeah, so from my side, in the end, I echo whatever my co-judges mentioned. And the only thing is, I would like to tell you that your demeanor, your body language, the control over the situation, and about the negotiations, the parties and the mediator, you have done a wonderful job. For a moment, I lost that whether I am in a competition or whether I am, I am into a real mediation. I thought that I am sitting in the real mediation. Then I saw these two pretty mediators. They are sitting and they have to do their job. Today, I am not doing my job. So that is really good to watch this. And you people have raised the bar of this competition, because I am there in this competition for last 6 years, and I could see that how the bar is raising every year. So you people have raised the bar of this competition. Even Mia, very good friend of mine from Philippines, she asked me that whether you people are trained or not. Then I said, no, these people are not trained. They are just a student, maybe with the coaches or may not be with the coaches. So that is how it is done. But for your upcoming competition, suppose if you should get something from these sessions, how you performed or so, I may not be having that much time. If you want to connect one-to-one for getting more about you people, because I have my all notes with me, so I'll be happy to connect on LinkedIn or any other via email or anything. So I'll be happy to connect. But what I feel is that, see, mediation is something where you will have to give a momentum to a discussion. It should not be stopped. It should not be stopped. It should not be halt for one reason or another reason. So if you feel that you are stuck for something, you have to clarify that why you are stuck on this point, why this point is important for you, what if this clarity is not been on the table, and how it will impact on my future. So all these present, past, and future has to be very well articulated. So what I feel is, Manya, that when you say that I want to understand how you interpret this clause. So when you stuck on the interpretation, you have to be very mindful and very clearly you have to point out that why this interpretation is very important for you. How, if this has not been told, and how it will have an impact in the future, and how you are struggling for today. Or alternatively, suppose they are stuck, then you should have asked for the breakup, like how it can be breakup, how how you are, because you want to understand the quantum. So how that quantum can be breakup, so that can be done. And for you, if suppose they are stuck on something, so it is your job to ask that why you are stuck on this, what is the apprehension, why you are not moving further, because mediation is to pull the other party on the negotiation, so that there should not be any disparity. So I feel that if suppose she was stuck and she was saying again and again, I'm not stubborn, but she was stubborn a bit, and then it's your job to pull her out and ask her that what is your apprehension. Is there any something you are feeling that we interpret this clause something differently, and I could not see answer from your end that how you interpret this clause differently, how they interpret it. So that is one thing I would like to highlight. And second thing, which is very important, is the caucus. You went, the responding party went into the caucus, and then they discussed something, and then they come out, and the requesting party, they did not ask that what was the outcome there, what happened there. If there is something which could be shared to them, so that it could be a reason for getting the discussion ahead. So that was not discussed. And second thing is, the moment they come out from the discussion, there was a sudden offer, which you clarified right now, that what was the sudden offer and why the sudden solution is. So sometimes the reasonableness in the mediation carry a lot of mark, right? So that is something which is very important to understand, that if suppose you are coming up with sudden offer immediately the moment there is a breakup, that should also be justified, that why this sudden offer and what you thought and how this sudden offer comes. Because otherwise this much of leverage in the mediation sometimes gives a different kind of understanding, that afterthought or maybe suddenly. And I understand that why you did not take up the this caucus also, I understood that. Yeah. And other thing for the mediator, that paraphrasing, reflections, and understanding the emotion, separating the people from the problem. See, all those things are basic. I was waiting for that at least, summarizing is one aspect, but reflection and, this paraphrasing, where you will be shifting the position to interest, where you will shifting the focus from one person to another person and present to future. So that was something, we need to work. Both the mediators need to work on that. But see, this comment is not for this session, but this comment is for your future competition. And if you want to know more, each of you, I am happy to give you, independent feedback, right? So this is all from my end.
Personal feedback.
Yeah. Over to you, Daisy.
I was the mediator.
Thank you so much, judges, for your valuable feedback. Thank you so much, participants, for joining us in the final rounds as well. All the best to each and every participants. We will be starting the valedictory ceremony sharp at 5 p.m. today. So requesting all of you to join. We'll be announcing the results there. Thank you, everyone.
And thank you so much, Mia and Hannah.
Thank you so much.
Respected
This was fun.
Yeah.
Yes, ma'am.
Thank you so much, ma'am. It was a pleasure. Thank you.
Thank you.
Respected judges, we request you to also join the valedictory ceremony.